I am going to be reading to you the court transcripts from 2023. These charges are stemming from the crimes that were committed against baby Promise Faith in 2018. Notice how Vanessa Avina and Jake Haro had separate hearings on the same day. I will be reading them word for word. Notice how Vanessa Avina got a misdemeanor and Jake Haro got a felony from this. Let's read these 2023 transcripts. People of the state of California, plaintiff versus Vanessa Avina and Jake Mitchell Haro. This hearing was held June 8th of 2023 with appearances made by Sam Taloa for the Office of the District Attorneys, Joshua J. Hain for defendant Vanessa Avina, Vincent Hughes for defendant Jake Haro. And as you guys can see, we have the pictures here so you guys can understand who these people are. June 8th, 2023, and it's a morning session. Before the Honorable Dwight Moore, the judge, the court speaks. Vanessa Avina, Mr. Hank, speaks. Good morning. Joshua Hanks for Miss Avina. She is present out of custody. Mr. Taloa. Good morning, Your Honor. Sam Taloa for the people. Mr. Hanks. Your Honor, this was a case we had discussed a couple of weeks back, and your indicated was a 17B with the probation term that I've indicated there. The court. And this is a plea to the court, Mr. Hanks. This is, Your Honor. And we had also discussed, because she is required to do the 52-week child batterers course, whether or not the court could be inclined to give her credit if she had already done that course. I submitted proof that she's done 40 classes of the 52. She's spoken to the class and they're amendable to allowing her back in if the court is okay with that. The court speaks. What I would do in a situation like this, counsel, is order her to do the full 52-week course and indicating that it is up to the program as to whether or not they believe it's appropriate to give her credit for what she's done or whether she needs to start again. I'm leaving the decision to them. Let me time out right here. I'm a little lost here because I don't know why the court would make her do the child batterers program again or why she would have to restart, but let's keep going. Mr. Hank, attorney for Vanessa Avina, speaks. Perfect. Could we just have it reflect in the minutes that the court has no objection to that? The court speaks. Yes. Mr. Hank speaks. Thank you. The court speaks. All right. Miss Avina, I've received a form from you entitled Misdemeanor Plea Form. I'm showing you the form. Did you read this entire form? Vanessa Avina speaks. Yes, sir. The court. Did you place your initials in each of the boxes and sign the form on the last page? Vanessa speaks. Yes, Your Honor. The court. The form indicates that you're going to plead guilty as charged to count 1, Penal Code Section 273A, subsection A, child abuse. Based on our discussions, I have decided that I would accept a plea to a misdemeanor, although the district attorney has charged it as a felony. Let's pause right here. District attorney charged this as a felony. Judge accepted a plea as a misdemeanor. This is again for the 10-week-old baby. Everybody knows the severity and the things that this 10-week-old baby went through. Okay? Imagine all of this for a misdemeanor. Let's keep going. The judge further speaks. What I indicated is you'd be placed on probation for a period of 4 years. It's formal probation. I'd order you to do 120 days of work release, weekend work release. You're eligible for halftime. That may be pick up the garbage by the side of the road or whatever else they have you do. You have to attend and complete a year-long child abuse program. I said it before, and I'll say it again on the record. I'm told you've done most of the program already. I will not object if the program decides to give you credit for the classes you've already done. Also, if the program says, no, you need to start all over and do it straight through, that's okay too. That's up entirely to the program. I'm leaving that up to them. And restitution, if there's any bills you need to pay as a result of this, you'll deal with that down the road. Is that your understanding of the agreement? Vanessa Avina speaks. Yes, Your Honor. The court speaks. Is this what you want to do? Vanessa Avina speaks. Yes, Your Honor. To the charge of child abuse, section 273A, subsection A, as a misdemeanor, how do you plead? Vanessa Avina speaks. Guilty. The court. Joint counsel? Counsel join? Mr. Hanks speaks. Join. The court says, I'll accept the plea. In this matter, I'll impose pronouncement of judgment. The imposition of sentence will be suspended for a period of 4 years. The term of probation includes 120 days weekend work release. Do we have any probation? Yes, we do. They are telling you to report to sign up for your weekend work release no later than July 7th. There is restitution fine of $150. The program, there may be other terms. There's a set of probation terms here. Did you read all these probation terms? Vanessa Avina speaks. Yes, Your Honor. The court. Did you go over them with your lawyer? Vanessa Avina speaks. Yes, Your Honor. The court. Understand them all? Vanessa Avina speaks. Yes, Your Honor. The court. Any questions? Vanessa speaks. No. The court speaks. Either about your probation terms or anything else? Vanessa Avina speaks. No. The court. All right. Then in that matter, you are on probation. This is a formal probation. You don't have to report to probation. You won't have a probation officer, but you need to do the program. File proof that you've completed the program no later than August 1st of next year. If they're only going to make you do 10 or 12 more classes, you'll be done and be able to file proof a lot sooner than that. But if you have to start over from scratch, you've got until August 1st of next year to file proof. If you're done sooner, file proof as soon as you're done with the clerk's office downstairs. That will be the order. So this is what Vanessa Avina was given by Judge Dwight Moore. Okay, let's keep going. Mr. Hanks, attorney for Vanessa, says, thank you, Your Honor. Vanessa Avina speaks, thank you, Your Honor. Okay, other matters are heard. Vanessa Avina was the morning session. Here we have the afternoon session with Jake Haro. June 8th, 2023, afternoon session. The court speaks. Let's call the matter of Jake Haro. Mr. Sarmiento speaks. Good afternoon, Attorney Randy Sarmiento, Sarmiento, especially appearing for attorney of record, Mr. Vince Hughes, Hughs. The court speaks. Good afternoon, Mr. Sarmiento. Good afternoon, Mr. Taloa. Good afternoon, Your Honor. Sam Taloa for the people. The court speaks. Thank you. Mr. Haro, good afternoon, sir. Defendant Haro speaks. Good afternoon. The court speaks. Mr. Haro, I have received from you a form entitled Felony Plea Form. I'm showing you the form, sir. Did you read this entire form? Defendant Haro speaks. I did. The court. Did you place your initials in each of the boxes, sign and date the form on the last page? Defendant Haro speaks. I did. The court. Did you understand everything on this form, including all of the legal rights and all of the penalties, punishments, and consequences of entering this plea that were listed on the form? Defendant Haro speaks. I do. The court. Do you understand, sir, that if you plead guilty in this case, you will be giving up some of those legal rights? Those include your rights to a speedy and public jury trial, your right to confront and have your attorney cross-examine the witness against you, your right to subpoena witnesses and evidence in the court on your behalf, and your right to remain silent. Are you willing to give up each of those rights so you can enter into this plea? Defendant Haro responds, I do. The court speaks. My understanding of the plea is that you are pleading as charged to count 1, Penal Code Section 273A, Subdivision A, child endangerment. This is as a felony. The agreement is that I would sentence you today to 6 years in state prison. I will then suspend execution of that sentence, placing you on formal probation for a period of 4 years. Terms will include 180 days as a term of probation. Is that your understanding of the agreement? Defendant Haro speaks. I understand. The court speaks. Other than what I just read to you, has anyone made you any other promises to you to get you to enter to this plea? Defendant Haro speaks. No. The court speaks. Has anyone made any threats to get you to do this? Haro speaks. No. Are you under the influence of any alcohol, drugs, or medication right now? Haro speaks. No. The court. Have you had enough time to discuss your case with your lawyer, including your legal rights, defenses to the charges, and the consequences of entering into the plea? Haro speaks. I have. The court. Are you satisfied and do you understand all those things? Haro speaks. I understand. The court. Do you also understand if you're not a citizen of the United States, the consequences of this conviction will include deportation, exclusion from admission to the U.S., and denial of naturalization? Defendant Haro speaks. I'm a citizen. The court speaks. You also understand that if you are placed on probation, there will be a long list of probation terms. Defendant Haro speaks. I understand. The court speaks. Counsel, have you had enough time to discuss all these issues with Mr. Haro? Mr. Sarmiento speaks. Yes, Your Honor. The court speaks. Did you go over the change of plea form with him? Sarmiento speaks. Yes, Your Honor. The court. Are you satisfied that he understands everything on the form? Sarmiento. Yes, Your Honor. The court. Do you join in his waivers? Sarmiento speaks. So joined. The court. I'll find the defendant has read and understands his change of plea form. He understands the nature of the charges, which he's pleading, all punishments and consequences for that offenses, and each of his constitutional rights. I'll find he has knowingly and intelligently, freely and voluntarily waived each of those rights. Sir, is your true name Jake Michelle Haro? Defendant Haro speaks. No. What is it? The court is asking. Defendant Haro speaks. Jake Mitchell, Mitchell. The court speaks. We have it misspelled. The correct spelling of the middle name is MIT. Defendant Haro speaks. Yes. The court. Okay, Mitchell. Is your true name Jake Mitchell Haro? Defendant Haro speaks. Yes, Your Honor. The court. AKA, in this case, BAF 2101265, the charge in count 1, child endangerment, Penal Code Section 273A, Subdivision A, as a felony. How do you plead? Defendant Haro speaks. Guilty. The court. Counsel, join in the plea? Mr. Sarmiento speaks. Yes, Your Honor. The court. And this is a plea to the court. The people are not joining, correct? Mr. Taloa speaks. Correct. This is important right here. Let me time out. Let me reread that part. The court says, and this is a plea to the court. The people are not joining, correct? Mr. Taloa speaks. Mr. Taloa is for the people. Correct. The court says, all right, counsel, are you willing to stipulate? Has this case been to prelim yet? Mr. Taloa says, no, Your Honor. The court says, are the parties willing to stipulate that if I refer to the police reports in this case, I would find a factual basis for this plea? Mr. Taloa speaks. Yes, Your Honor. Mr. Sarmiento, again, attorney for Jake Haro, who's standing in for Vincent Hughes, says, yes, Your Honor. The court. I find the defendant has personally and orally entered his plea in open court. The pleas are free and voluntary. knowing and intelligent. There's a factual basis which I'll accept and confirm. Sir, you have the right to have me postpone your sentencing. Refer your case to probation for a pre-sentence investigation and report, and be back for sentencing within 2 days. My understanding is that you wish to give up those rights, and you want me to go ahead and sentence you right now. Is that what you want me to do? Defendant Haro speaks. Yes, Your Honor. The court. Counsel joined that waiver? Sarmiento speaks. So joined. The court. Waive arraignment for sentencing? Sarmiento speaks. No legal cause. The court speaks. I'll make the following findings. Was a motor vehicle involved? Sarmiento speaks. No, Your Honor. The court speaks. A motor vehicle was not involved in the incidental commission of this offense. Actually, before I go any further with the findings, I'm going to do this. Probation is denied. There's one thing here. In addition to the plea, are you stipulating, sir, pursuant to Rule 4.421A3 of the California Rules of Court, that the victim in this case was particularly vulnerable? Defendant Haro speaks. Yes, Your Honor. The court speaks. Counsel, join in that admission as well. Sarmiento says, yes, Your Honor. The court speaks. All right. Then on that basis, probation is denied. Based on the defendant's stipulation and the plea agreement with the court, the defendant is sentenced to the aggravated term of 6 years in state prison. I want you to let that sink in for a minute. I just sentenced you to 6 years in state prison. I will suspend execution of that sentence and place you on supervised probation for a period of 4 years. But if you violate your probation, you've already been sentenced to 6 years in prison. There will be no argument about, well, that's too much. Maybe we should give him less. No, you've already been sentenced to 6 years. Do you understand that? Defendant Haro speaks. I do, Your Honor. The court. All right. Then I'll suspend execution of that sentence. I'll go back to making my findings. I'll order the defendant to pay court fees $40 plus $30 for a total of $70, as well as a victim restitution fine of $300. That's a total of $370. I order you to pay at the rate of $25 a month, with your first payment due August 15th. Can you handle that? Defendant Haro speaks. I can. The court says that will be the order. $25 for restitution payment. I mean, I'm pretty sure I don't think he was employed around that time, but damn, $25 a month for all the ish that he did to promise faith, like that's ridiculous. Let's keep going. I'll also impose probation, revocation, restitution fines of $300, stayed pending successful completion of probation. That means you don't have to pay the last $300 fine unless you violate your probation. If you violate your probation, you have bigger problems than the $300 fine. The terms of probation includes a year long. I can't remember the name of the program. The child batterers program. You must file proof by July 10th that you've enrolled, proof by July 22nd of next year that you've completed the program. File proof with your probation officer. Also, 20 hours of community service through a nonprofit. File proof of that. You've completed that before July 22nd of next year. You have a year to do 20 hours. That shouldn't be too hard. You're ordered to do 180 days. You're eligible for weekend work release. You're eligible for halftime. I'll order you to report to any Riverside County jail by July 15 of this year to get that weekend time done. Again, you've got plenty of time to get it done. There are more terms of probation. I have not read all of them to you. Did you read all of your probation terms? Defendant Haro responds. Yes, Your Honor. The court. Do you understand them all? Defendant Haro speaks. I did. The court. Do you have any questions at all about your probation terms or anything else in your case? Defendant Haro speaks. I have no questions. The court. Do you need me to read all of these terms of probation to you out loud right now? Defendant Haro speaks. No, Your Honor. The court. Thank you. Do you accept probation on all of these terms? Defendant Haro speaks. I do. The court. That will be the court order. As of this moment, you are now on probation. I'm going to order you to report to probation as soon as possible. You're not going to be able to do it today. Tomorrow, you sign in with probation by 2 o'clock in the afternoon. On Monday, if you haven't done it by 2:01 on Monday, you're already in violation. And you know what that means 6 years in prison. Make sure you get signed in. Make sure you comply with all these terms. In addition, there was previously a protective order that applied to Carolina Haro, and I'm terminating that at this point. And I have a new protective order that also applies to Carolina Haro. You're ordered to have no contact whatsoever with her. You must not contact her directly or indirectly by any means, including telephone, mail, email, or other electronic means, or through a third party. Only contact through your attorney is permitted. This is a court order. You will receive a copy before you leave today. If you violate this, you're committing a whole new criminal offense and it's a term of your probation. So if you violate this order, you'll be violating your probation. Is he the parent of the child? Mr. Taloa for the people speaks. Yes. Is there any juvenile court family CPS? What is the status of that? And I mean, typically, we will permit contact pursuant to and only pursuant to a subsequent court order regarding visitation. Mr. Sarmiento speaks. Your Honor, I have no objection to checking the box reflecting the incorporation of any future family court order. The court speaks. That's 14B. Mr. Sarmiento, that's fine, Your Honor. I believe I don't have all the details, but there's another family court order. Is there an order providing for custody already in existence? Mr. Sarmiento speaks. Based on my brief discussion with him, yes. He does have visitation at last once a month. The court speaks. The problem is, I don't have a case number for that. Mr. Taloa speaks. I don't have access to that either. The court asks, do you have any more court appearances coming up in that case? Jake Haro responds, I do not, Your Honor. The court speaks. What are the provisions in that case? Jake Haro speaks. Vanessa Avina was allowed 2 days a month. I was allowed one. I haven't seen my kids in almost 3 years. The court speaks. Because we don't have those details, it would normally be in the form of I'm amending the language to say it's a no contact order, except you may have peaceful contact as an exception to the no contact order, only for court order visitation as stated in any family, juvenile, or probate court order issued before or after the date this order is signed. Is that agreeable to both sides? Mr. Sarmiento speaks. I would agree with that. Mr. Taloa speaks. Yes, Your Honor. The court. Okay. That will be the order. Mr. Sarmiento speaks. Thank you, Your Honor. The court. If you go outside the scope of your court permitted visitation, you're violating this order. And you know what that means? 6 years. So don't. I think that covers everything. Counsel, is there anything else I need to address? Mr. Sarmiento speaks. Just very briefly, two things. We are requesting for a Prop 63 hearing. He does currently own firearms. He owns a firearm. Let me pause right here. Okay. He owns a firearm. All right. He was recently violated because he had a firearm. The court responds to Mr. Sarmiento. Let's keep going. I'm sorry, start over. This is what the court says. I'm sorry, start over. Mr. Sarmiento speaks. He does currently own firearms, so we're asking for a return date for a Prop 63 on 7-19. He will surrender or legally transfer the firearms by that date. I'm not sure if the court wants to schedule that in. The court speaks. I think we need to put that on the calendar. Did you say July 19th is a good date? Mr. Sarmiento speaks. Yes, either I'll be there or Mr. Hughes. The court speaks. Let's schedule it for July 19th. We'll put over the matter and the defendant will be required to bring proof that all firearms have been disposed of, whether it's transferred or sold. Problem? Mr. Toloa for the people speaks. Not with that. I'm just curious. I've never had one set. Does that require the appearance of the people, or is it just verification between the defendants and probation? The court speaks. Somebody will be here. Mr. Sarmiento speaks. It's a non appearance type of thing. Mr. Taloa says, okay. Mr. Sarmiento speaks. Last thing, Your Honor, he does live in Cabazon, so the nearest probation would be Banning. I believe he was ordered to check in there. Would the court says, is that what's in the terms? Mr. Sarmiento speaks. When I was reviewing it, I know it's a report to probation. Would the court and the people have any objection to reporting to Banning for any future probation? The DA, Mr. Taloa, speaks. No. The court speaks. He has to report to probation in Riverside County within the time frame that I gave him. If he lives in Cabazon, yeah. Mr. Taloa speaks. Okay. The court. Go to the closest one. I'm not seeing it specified that it has to be downtown. If it does say that here somewhere, I'm overriding that. And yes, he can report in Banning. Mr. Sarmiento speaks. Thank you. We'll just hang tight for the protective order and the paperwork. Thank you. Mr. Taloa for the people speaks. Your Honor, I would just ask for the record to reflect that the people are objecting to this and that this is based on the severity of the injuries as we discussed to the victim. And our offer was, in fact, prison for this case. The court speaks. Understood. Mr. Taloa says, thank you. The court says, I acknowledge that when I said it was a plea to the court and the people aren't joining in it. I appreciate that. Under the circumstances, I think this is appropriate, and we have hung a very high, large hammer over the defendant's head. If he violates, he'll end up going to prison for a lot longer than if I had taken the DA's deal. I'm giving you a chance. Don't mess it up. Good luck. Mr. Sarmiento speaks. Thank you, Your Honor. Defendant Haro. Thank you. The court. Thank you. And that is how the June 8th, 2023 hearing ended for both Vanessa and Jake Haro. Guys, let me know what you think in the comments. I mean, knowing what we know now, who do you guys hold accountable? Do you hold everybody accountable? Let me know what you guys think in the comments. And I'll see you guys on the next one. Rabbits out. Bye, guys.